Good morning, everybody. Happy Friday. Welcome to the Courtroom Files Live. We will start our day with Judge Simpson. He is doing his Parade of Misery, the world-famous landlord tenant docket.
Mr. Redwine, how are you intending on getting that paid?
I'm gonna pay something Friday. I'm gonna pay something Friday. Then I'm gonna pay another 1,600. 2 weeks after that, then yeah.
Okay, so how much can you pay by next Friday?
I'm pay 750 Friday. It's Friday.
Okay, so 750 by the 30th. It looks like something's going to have to be worked out regarding a payment plan or something, if it can be. So then I'll adjourn this out May 30th, 2025 at 3 p.m. That will be in person. And then we can see if we can get something worked out. Okay, Mr. Redwine?
Okay. What time?
All right. That's at 3 p.m.
Okay, thank you.
Thank you.
Bye.
Court calls the case of Gulf Side Lakes versus Michelle Goebel and Marlon Goebel.
Jillian Egan for plaintiff.
Good morning. This is Michelle Goebel.
Okay, good morning. All right. How much is owing on this account?
I have a balance including court costs of $1,643.74.
All right. Ms. Goebel, how were you intending on getting that paid?
Yes, I get paid every other Wednesday, so I was planning on doing about 600 on the 28th, and then the remaining balance on Wednesday, June 11th, both before noon.
On June 11th?
Yes.
But is that that's going to include your June rent or no?
I think so. Yes, yeah.
All right. So here's what I'm going to do. You said you can pay 600 by the 28th.
Yes, sir.
All right, get that paid. I'm going to adjourn the hearing to May 30th, 2025 at 3 p.m. That's an in-person hearing. And I'd suggest that you contact plaintiff's attorney's office, see if you can work out some type of either conditional order, dismissal, or something regarding this case. Okay?
Perfect. Thank you so much.
All right. Thank you. Have a great day.
Again, you too.
Gulf Side Lakes versus Mia Salvano.
Jillian Egan for plaintiff.
Mia Salvano? No response. You've been sworn. You may proceed.
Thank you, Your Honor. This is the case for non-payment of rent. Rent to retain possession is $2,784.07. Court costs are $172 for a total of $2,956.07. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Can you give me that amount again?
Yep. $2,956.07.
Got it. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Hamilton Crossing 2 versus Tanisha Ballard.
Jillian Egan for plaintiff.
Do not have this down.
Tanisha Ballard. I do not have her. You may proceed.
Thank you, Your Honor. We're actually looking to do a conditional order of dismissal with this one. I can place terms on the record, and it's going to be submitted to the court.
Okay.
Okay, so defendant may retain possession of the leased premises through the end of the lease term, provided that defendant complies with the following terms. As of May 9th, 2025, defendant has an outstanding arrearage of $2,178, includes $172 in court costs. Plaintiff shall pay the outstanding arrearage as follows. And I realize that some of these dates are before today's date. The payments have already been made in compliance with this. $300 on or before May 10th, 2025, $285 on or before the 10th of each month from June through November, and then $168 on or before December 10th, 2025. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through December 25th, 2025. And then commencing January 1st, 2026, defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease.
All right. So I see those certainly as more favorable terms than the entry of a judgment in this case. So I'll enter the COD when it's presented with those terms.
Thank you, Your Honor.
Hamilton Crossing 2 versus Joshua Myers. And is it Sheriff Myers?
Your Honor, Jillian Ingen for plaintiff, forgive me, I switched my order. This is also a conditional order of dismissal. I gave these terms I'm sorry, no, this is right. Okay, I'm sorry. Sorry, Your Honor. Okay,
No,
Jillian
it's
Ingen for
okay.
plaintiff. Your Honor, we have a conditional order of dismissal for this case as well. I can place terms on the record.
Go ahead.
Thank you. Okay, defendants may retain possession of the leased premises through the end of the lease term, provided that defendants comply with the following terms. As of May 9th, 2025, defendants have an outstanding arrearage of $5,189, which includes $214 court costs. Defendants shall pay the outstanding arrearage as follows: $415 on or before May 10th, 2025, $181 on or before May 25th, 2025, $415 on or before June 10th, 2025, $415 on or before August 10th, 2025, and $260 on or before September 10th, 2025, $415 on or before October 10th, 2025, and continuing with $415 per month on the or before the 10th of each month through April 10th, 2026, $28 on or before May 10th, 2026. And then defendants shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through May 25th, 2026, commencing June 1st, 2026. Defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease.
All right.
So,
And I do see those terms as being more favorable than an entry of a judgment by default. So the court will enter the conditional order of dismissal.
thank you.
Court does call the case of Huron Vista Apartments versus Wilbur Burrell.
Jillian.
Good morning once again, everybody. Welcome to the Courtroom Files Live. Again, happy Friday, happy Memorial Day. Let's head south. What do you say? And we'll go to Jackson County, Florida. This is Judge Anna Garcia.
Side waiting to take him to golf. So come on up here, David.
Sure, fair enough. Mr. Broderick, good morning.
Good morning.
Mr. Broderick, tell me your full name for the record.
David Michael Broderick.
Mr. Broderick, did you understand the rights that were explained to you on the first appearance video?
No.
All right, let me explain them to you. Mr. Broderick, you have the right to remain silent. Anything that you say during this proceeding can be used against you. You have the right to an attorney. I'm appointing the man to your left to be your attorney for purposes of this first appearance. Finally, you have a right to be to know why you are here, and you are here for a warrant out of Gulf County, Florida. That warrant alleges that you may have committed the offense of sexual battery by someone over the age of 18 on a victim under the age of 12. Gulf County has confirmed that that is a valid warrant and that they will pick you up. And it is my understanding that they are outside ready to transport you to Gulf County. All right.
All right.
Thank you, sir.
Richard. Start at the top, Your Honor. So Richard Stasko.
Okay, fair enough. Mr. Stasko, good morning.
Good morning.
Mr. Stasko, tell me your name for the record.
Richard James Stasko.
Mr. Stasko, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
Mr. Stasko, you are being held for allegedly violating the terms of your state probation out of Washington County for the underlying charges of possession of methamphetamine. So what that means is you will be held until Washington County comes to get you here in Jackson. It probably will be today. It may be a day or two. And then you'll answer to those charges there. Do you have any questions for me?
I was just told by my probation to let y'all know that I found a rehab that I'm trying to get into.
Yeah, I think that's really important for you to let Washington County know, okay?
All right.
Definitely let them know that, okay? Good luck, sir.
Bradley Herman.
All right, Mr. Herman, good morning.
Good morning.
Mr. Herman, tell me your full name for the record.
Bradley Chase Herman.
Mr. Herman, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
Mr. Herman, you are being charged with one count of grand theft, more than 5,000, less than 10, and one count of acting in the capacity of a contractor without being registered or certified. The judge who signed the initial warrant, it was Judge Mercer, has already made a probable cause determination. However, I do also find there is sufficient probable cause for both of those charges. The grand theft is a third-degree felony, punishable by up to 5 years in prison and/or $5,000 fine. The contracting is a first-degree misdemeanor, punishable by up to 1 year in jail and/or $1,000 fine. Sir, are you on probation anywhere?
No, ma'am.
Do you have any pending criminal charges?
No, ma'am.
Mr. Herman, it's my understanding you have no criminal history, correct?
Yes, ma'am, that's correct.
All right. Mr. Herman, some individuals have reached out on your behalf. The state and the defense have had an opportunity to review that. I am willing to offer you two alternatives if you wish to go out. Or is there anything further from the state or the defense?
No, Your Honor.
No, Your Honor.
I'm offering you two alternatives. If you wish, you may be released on a conditional release, and there are certain standard conditions of that release. But the special condition will be that you may have no contact with the victim or the victim's property. Additionally, you may be released on a bond. The bond would be $5,000 for the grand theft, $1,000 for the contracting, total bond $6,000. No contact with the victim or the victim's property. Mr. McDaniel, in light of the email that we received, is there any request for an alternative cash bond?
Your Honor, you okay with the cash only bond? I mean,
Something like, I would be willing to do something in the neighborhood of 1,000 for both if he wanted to do something like that, but really it's up to him because I'm also offering the CR.
It sounds like Mr. Stokes is gonna be, he owns bail bonds and companies also. So I mean, I suspect this, he's gonna take care of him no matter what. So
Yeah, I mean,
so the bond is the $6,000 cash assurance.
So
bond.
he can decide that later. I mean, so I've already given the option, the CR or the bond, and you can make the decision which of the two you want to use, okay?
All right, good luck to you.
sir. Thank you, ma'am.
$6,000.
Good luck to you. Is this
We
Tara
have, Tara
Peters?
Peters.
Yes, ma'am.
Good morning, Miss Peters. Tell me your full name for the record.
Tara Nicole Peters.
Ms. Peters, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Ms. Peters, you are being held for having an active warrant out of Calhoun County. John, were you able to see what that was?
Violation of probation.
The OSP? All right, for allegedly violating your probation or county, maybe?
It was state. I don't know if it was probation, but I'd seen the warrant. It said hold without bond. I did look at the warrant itself. It may not have been probation, but I did see a hold without bond.
But there was a hold without bond. I don't have a copy of the warrant, but if we feel comfortable with that, ma'am, Calhoun, I do have a copy of the teletype that confirmed a warrant out of Calhoun. And so you'll be held until Calhoun County comes and gets you. And it should probably be today, Ms. Peters, realistically, but it won't be more than a few days. Okay?
Okay, yes, ma'am.
All right. Good luck to you, ma'am. Do you have any questions?
Yes, sir. No, ma'am, thank you.
Tempest
All right, thank you.
Williams. Judge, I was gonna do Leah last.
Fair enough.
Tempest Williams.
Miss Williams, good morning.
Good morning.
Miss Williams, tell me your full name for the record.
Tempest Lenore Siobhan Williams.
Miss Williams, did you understand the rights that were explained to you on the first appearance video?
Yes, sir.
Miss Williams, you are in custody for allegedly committing the offense of aggravated battery with a deadly weapon. That is a second-degree felony punishable by up to 15 years in prison, and the charge of criminal mischief over 1,000. That is a third-degree felony punishable by up to 5 years in prison. Miss Williams, are you currently on probation anywhere?
No, ma'am.
Do you have any pending criminal charges at this time?
No, ma'am.
Is there anything from the state or the defense?
No, Your Honor.
No, Your Honor.
All right. Ms. Williams, having reviewed the probable cause narrative, I'm going to set your bond on the aggravated battery in the amount of $250,000. That will be cash or surety, and on the criminal mischief in the amount of $1,000, or excuse me, $5,000. That will be cash or surety. Total bond $255,000. Under either circumstance, you may have no contact with the victim if you are released on that bond. Do you have any questions for me about what the court has just announced in your release options?
No, ma'am.
All right. Thank you, ma'am.
Nathan Phelps.
You can hang out here for a minute. We don't know where we'll be. All right, is Jeannie over there? Give me 1 second, John. Jeannie's over there. We'll go over there. We'll go over there. I'm just doing first appearances. Okay. All right, Mr. Pelt, good morning.
Good morning, Ms. Garcia.
Sir, tell me your name, your full name for the record.
Nathan Gerard Pelton.
Mr. Pelt, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right. Mr. Pelt, you are currently being charged with allegedly failing to register on your state probate, as a offender as is required by law. I do find there is sufficient probable cause for that charge. It is a third-degree felony punishable by up to 5 years in prison and or $5,000 fine. Mr. Pelt, I'm going to set a bond in that case, and it'll be in the amount of $100,000. That will be cash or surety. If you make that bond, then you must follow all registration requirements. Sir, your total bonds between all the charges will be $200,000 cash or surety. Do you have any questions for me?
No, ma'am. Is it,
All right.
Let's bounce back up to Michigan and say good morning to Judge Jason Elmore.
Ms. Volker, who is in pretrial confinement, has now made her way to the defense table. Appearances from counsel, please.
Joanna Carey for the people.
May it please the court, Robert Champion appearing on behalf of Ms. Volker, who is seated to my left, Your Honor.
Thank you. One moment here as I make a few notes. All right. We're here today for a final pretrial conference. It's, I think, our third or fourth, quote unquote, final pretrial conference. I do recall that this case is a companion case with the one we just handled, which was People versus Root. And I understand that Ms. Volker is scheduled to be a witness in that case. The pretrial agreement in this case requires testimony in the Root case.
That's a correct statement, Your Honor.
Okay, so now that we know that Mr. Root's case is going forward to trial on June 10th, and this would have been the other case on backup for that trial. I need to ask the question. I don't remember. Does her pretrial agreement or resolution in this file involve her making a plea of some sort?
No.
No? Okay, so if she, go ahead and tell me what the agreement is involving Ms. Volker.
Not put it on the record right now.
Okay,
It would be beneficial to my client to plead, let's put it that way.
to plead,
I mean, to testify.
hold on, let me make sure, let me just cut through the fog. If it's going to result in some kind of plea to a charge in this file, I'd rather take care of it today.
That is not.
Okay, copy that. So the request is to leave this on as a backup trial for June 10th, knowing that Mr. Root's case will go on that day, barring any catastrophes of the world. Correct? Is that a good statement? Ms. Carey, you're looking kind of
Well,
stoic.
my concern is if for some reason his doesn't go, we don't want this one to go.
I'll deal with that. We'll deal with that when it comes, if that happens.
Okay.
But I've got to keep this thing moving. So I'm going to leave this set for a trial on the same day. If there is some catastrophe in case number one, then the parties can request a stipulation to present through a stipulation, a request to adjourn case 2. And Ms. Folker, you are number 2 in that scenario.
If everything works out, we should be able to resolve everything during that time frame.
Okay. Anything else?
No, thank you.
And if I recall, at this time, Ms. Folker is currently serving a sentence.
Correct, yes.
All right, so therefore I don't need to address any bond issues.
Not at this time, Your Honor.
Thank you very much. We are adjourned.
There's a lot of courts that appear to have taken the morning off. I'm not surprised by that, but there's still a lot of action out there. Michigan and Florida is especially where it seems to be at. Let's go back to Florida. This is Brantley Clark in Bay County, Yes, Bay County.
The court. Deputy, any objection?
Yes, Your Honor.
There's an objection? What's the objection?
Given the nature of the charges involved, the state would ask that you do not reinstate bond, or if you do, that.
Basically, I'm just asking about these certificates.
Oh, no objection to that, Your Honor.
Okay, go ahead. All right, go ahead, Mr. Peacock, and I'll allow the state to respond after that.
Sure, of course. Judge, I can proffer, or I can put him under oath either way, or I can also put his mother under oath, who's in the audience. Bottom line, what we have here is a domestic violence charge that got created by this man's wife. They have a small child together. I have a letter by an adult witness who is basically saying that the wife made all this stuff up to get him arrested for the domestic violence stuff. That's what violated his probation and got him back in jail. His mother is sitting in the audience. I've also talked to his adult sister. They're willing to post bond again or to reinstate bond again. Here's the problem. The DCF and the child protection team people are about ready to take his children and put them in foster care. And this is the main reason that he wants to get out, is to take care of that problem. His wife, the one who is alleging the domestic violence, has admitted that she made all that stuff up to try and get him arrested to get control over the child. She is currently sitting in the Bay County jail for her own set of problems, which she has from some other issues that I'm not totally familiar with. But she is in jail. You did sign an order in the past on the domestic violence. You signed an order allowing for peaceful, lawful contact between the husband and the wife. And as they're both now sitting in the Bay County jail, I've discovered that the jail has a program, and unless they change the name of it, I think it's called the green file or the green procedure, where, what is it? Green sheet. There's a green sheet process in the jail. When you have a couple or you have adult parents that are in the jail has allowed this green sheet method of inmates communicating about their children, hopefully to try and prevent the children from getting put in foster care or adopted away from them. So what we have is kind of a unique situation, and I haven't had one of these quite like this in a long time. We got adult parents, they're both in jail, they both have their own set of problems. The wife has created the big problem with the domestic violence issue that got him violated on his probation situation. The wife is the one that made all this stuff up about domestic violence and got him charged. I've got a letter right here from a state witness and from a defense witness, actually. His name is Daryl Temple, and he was there that night. He observed some of the scratches and injuries to my client's face that were committed by his wife, who is currently in jail and very apologetic about what she did. So I know the state probably doesn't, have privy to all that, but I'm prepared to share with him the written letter from the adult witness. I'm prepared to tell this court, you've already signed for lawful and peaceful contact on the domestic violence case. We did that so that they could have this green sheet method. Now here's the ripple or the roadblock. The jail green sheet method, whatever it is, they haven't in the jail understood or allowed that yet. And my client is in one side of the jail, his wife is in the other side of the jail, and they're not able to communicate.
What's the wife charging?
I'm not sure, and I'm not. What?
Yes, sir. It's aggravated child abuse on her 14-year-old daughter.
Because I'm not, he's got a charge of child abuse. Is that correct?
Yes, as a result of his wife.
I'm not sure that DCF is in a position to and they have to
Judge, I'll be candid with you. I've tried communicating with DCF,
Yeah.
with anybody in CPT. It's like talking to people.
I would doubt right now that they would be in a position to ask, and I don't know if they've taken the child into custody, but they took the child into custody, they'd have to go to this juvenile judge and ask that they be placed with a parent who has a child abuse charge. So that's not going to happen. I'm not going to consider letters or anything. I don't know what's this, the state's objecting. If the state wants to take some time and talk, and I guess who's got the mother's case?
I do not know.
On that,
He's charged.
You know who her attorney is?
He's charged. I'm not prepared to reinstate his bond at this time on the cases that he was out on bond for. Based on the state's made a charging decision, charged with battery by strangulation and child abuse.
Judge, could I call the audience and ask if there's is there a DCF worker or a CPT worker on this case here? Anybody? Okay, I'm not surprised. That's all I can say on that. Bottom line, Judge, the state agencies regarding the children are anticipating putting those children in foster care and/or.
Well, they wouldn't be considered placing the child with the father if he's got a child abuse charge.
I understand. And that's why I'm inviting the state's attention to talk to the mother.
That's not something I can do. What I can do is I'm going to deny the motion. I'll deny it without prejudice.
Okay, thank you. That's a start.
And see, we need to set another court date. Just set it for June 19th at 9 o'clock, and that'll allow you some time to do that. Okay?
All right.
oh, can I,
You can tell him what you wanted to tell me about this situation.
All right.
Okay? Judge, may I put him under oath?
It's not going to do anything. It's
No,
not
it's not gonna change his
I
mind.
understand.
anything.
I understand, sir. I was just
And
wondering.
I don't need to consider anything else right now. I'm doing it without prejudice. So if there's something else, the state will.
Is you approved for me to talk to the wife?
Yeah, Judge, he's asking, can he have peaceful, lawful contact?
Didn't
with
he already
his
have
son?
that? Isn't that already?
No, I mean.
It's
with
just
my-
the wife that we were asking.
Yeah, I was like, cause I was talking to my son for months on end and then they all of a sudden stopped it. And then now that he said you have to approve it where I could talk.
I'll allow supervised contact with the child.
Okay, thank you for that, Judge. And how old is that child?
He's 4. That's my only child.
All right, then we'll work that through your mother and sister. Thank you, Judge.
Have supervised contact. Okay?
Okay, we'll talk. Have a seat. Thank you.
Mr. Turner? Mr. Peacock.
Let's head to Texas. Say good morning to Judge Boyd.
Dixon. He's over there. He's in there. I've talked to Dr. Murphy, but she has not yet seen him. And I'm hoping. Needs to come down. Oh, okay.
All right, thank you.
All you should eat, that's mad. So, Judge, I want Dr. Murphy to be able to.
1 second. Deputy Mejia.
I'm gonna hold him back.
All right, thank you. I appreciate it. All right, yes.
Okay.
Hi.
Good morning. I want Dr. Murphy to be able to visit with him
Okay.
before we discuss the hearings that were set for today. Can you delay this hearing for 2 weeks?
All right.
Yeah, okay.
And a hearing for what?
We're currently on a bond reduction.
Okay.
It was, Judge, I think it was sua sponte file because I did not file any motions for bond reduction. He is remanded without bond on 2 of his cases, okay on the other. But I really want to get the Dr. Murphy interview done before I address his bond.
All right, so his, let me see.
Oh, and I've also conferred with the state and they're okay with a 2-week reset on that.
So his plea deadline date is actually June 23rd.
Yes, Your Honor.
All right. So how much time are you asking for?
Just 2 weeks to come back on the bond issue.
All
And
right.
hopefully Dr. Murphy will have been there to visit about
I'll
it.
tell you what I'll do. I will, I can set it for June 9th, if you want June 9th.
June 9th, Monday is good, Judge.
All right, Ms. Ferguson on Dixon is coming back for June 9th. Yes, and they want a bond hearing. Yes.
I'll follow the appropriate motions to come back.
State on Dixon, they're coming back on June 9th for a bond hearing. He's remanded without bond, defense counsel tells me, on a couple of his cases. All right, thank you.
Okay, thank you, Your Honor.
Okay.
So I'm dropping a link in the chat right now. This is from Kazman. This is the New York Post article on the Megan story. Now, if you are a channel member and you joined us on our pre-show today, Kazman, who is one of our channel members, joined us, and he told us a story about the person involved in this kidnapping murder because he knew that person. That was a person that he was acquainted with. So he told kind of his knowledge and his side of what went on, and it was really entertaining. And that's the kind of thing that we do on the pre-show. So if you want to be part of that, you have to be a channel member. So $2.99 a month, super inexpensive. You get a lot of extras, but one of the biggest things you get is a pre-show 30 minutes prior to this show. Every day we do a live. Again, $2.99 a month is all it costs. There is a link to it in the pinned chat. We would love to have you as a channel member. Let's go back to Michigan. But we're going to visit a judge that we haven't done before on the live. This is Judge Stasia Buchanan in Lansing, Michigan. We'll see what's going on there.
Yes, ma'am.
Thank you. Today is the date scheduled for probable cause conference. I understand, Mr. Kaplan, you just got to meet with Mr. Thompson. Have we decided what we're doing about the preliminary exam set for next week?
Your Honor, we have. Well, we haven't decided what we're doing about the exam. In talking with Mr. Thompson, he is currently being housed at the Center for Forensic Psychiatry under a probate court order. But I also have concerns about criminal responsibility. So I'm going to need to request a criminal responsibility evaluation before we move forward in this. Actually,
No, you can't have that before preliminary exam. You can have it before trial, but not before preliminary exam.
All right. In that case, Your Honor, we will hold the exam. There's not been an offer made in this case at this point. I just want to put that on the record.
That is correct.
If competency is an issue, we can do that now, but we can't do criminal responsibility now.
Okay. Now, I'm not concerned about competency, Your Honor.
Okay. So you want to leave it on for exam next week?
Well, I guess the only issue is transporting him, if we're going to be able to bring him here from CFP or not.
I'm guessing we'll do a writ and see if we can get him.
Okay.
Okay. Anything else we need to address?
Yeah, I would just note that we had 8 witnesses subpoenaed for exam. So just it would probably be one that would take a while.
Okay.
So just a heads up.
Okay. Good to know. All right. Anything else from you, Mr. Kaplan?
Not from the defense, Your Honor. Thank you.
Okay, Mr. Thompson, your exam is set for May 30 at 9:30. It's in person. So if you're still at the center, we'll try to get transport to bring you over. If for whatever reason you were at liberty at that point out on your own, make sure you get here so that we can take care of this case. You do have a no contact order for Christine Bradford that continues, whether you're at the center or out in the community or anywhere else, that no contact order applies. No contact whatsoever, not to be within 2,000 feet of where she lives, works, or goes to school. If you violate that order of no contact, you could be arrested without a warrant. Any bond you posted could be revoked. You could be in contempt of court, for which you face 93 days in jail and or $7,500 in fines consecutive to that which you already face. Understand?
Yes, ma'am.
Okay. Also understand that she cannot give you permission to violate this court order. It's the court's order, not her order. So if she reached out, wanted to talk to you, or wanted you to meet up with her, and you went, you could still go to jail because she cannot give you permission to violate the order.
Yes, ma'am.
All right, that will conclude this proceeding. Mr. Thompson, I'll see you next week.
Yes, ma'am. Thank you, Your Honor.
1 second, Your Honor. What time
Yep.
did you say it was next Friday?
It's at 9, right?
Yeah. 9:30.
Oh, 9:30. 9:30 in the morning.
Yes, Your Honor. Thank you.
You're welcome. On the record in State of Michigan versus Ray John Johnson, 2501472 FY.
Ross Marchmino for the people.
Your Honor, Jeffrey Kaplan, P74943. Your Honor, if I could have a breakout room to speak to my client.
You can try, but the problem is that while we were waiting for you, he disconnected the Polycom on us once already. So I'm not sure how cooperative he's going to be today. I also was uncertain about whether he was responding to internal stimulus. So are you intending to file a petition?
I was going to talk to his other attorneys, but I need to talk to him in more detail. I need to try and talk to him in more detail.
Okay, if I can get him unmuted, I'll try and get you into a breakout room. Just wait a second here. We'll see how it goes. Okay, he's unmuted now.
They faked this nigga for.
Okay,
Thank you, Your Honor.
you're welcome. Are we holding the exam for Smith?
Looks like we are.
Okay,
We'll finish.
okay. Yep, hopefully we'll be able to do that in just a moment. I guess we should get him brought up. Let's go back to Judge Boyd in Texas.
All right. Mr. Davis.
Yes, Your Honor.
All right. So here's the thing. Whatever agreement you all are able to come up with, that's whatever agreement you all are able to come up with. Now, I understand that sometimes people will look at cases differently. And when they look at them, they think it's the range of punishment is something else. But then when they discover that there are enhancements involved, then your range of punishment increases. So on each of these cases, they are proceeding on you as a habitual. So normally where your range of punishment may be at a state jail level, it is not when you're being habitualized.
Yes, ma'am.
Now, when it's a habitual in the count, for example, this unauthorized use of a vehicle, normally that's a state jail felony, 180 days, up to 2 years in the state jail facility and up to a $10,000 fine. That's normally what the range of punishment is. But Texas has enacted through the legislature that if somebody has been to prison before or has previous felony convictions, their range of punishment can be enhanced. What does that mean? That means that even though technically and legally it's a state jail felony, you're not at state jail felony punishment. Do you understand?
I understand it totally, Your Honor.
So here's the thing. The state has made an offer. Do you know what the state's offer is? That's either yes or no.
Yes, ma'am.
All right, state, your offer that you have made to Mr. Davis, is that your final offer?
Yes, Judge.
All right, so just 1 second. State, do you have any plans on changing whatever offer you made to him?
No, Judge.
All right, so they're saying that their offer won't be changed. So whatever offer they made you, that is the offer. Yes.
Okay, I'm just trying to get something straight because last time I got 2 6s concurrent. I signed 2 6s concurrent, but I picked up a case after the first one. I did 6 years, 10.5 months flat.
Mhm.
Right? So they're offering me a 4. Right?
No, I don't want to know what they're offering you.
Well, I got 2 charges. I just got this other charge. I've had the first charge since September, right?
So what are you saying? You don't think you're?
I got 2. They won't give me my back time when I get to TDC.
Well, let me just tell you.
So
they're
I'll do
not-
4 years,
let me
9.5
just tell
months.
you, they're not in charge of whether you get your back time or not. I'm in charge of that. And what I can tell you is
Put on your listening ears. Take a deep breath. All right, take another deep breath. This is what I want you to hear. If these cases were pending and you were not on bond for these cases, right? If they're pending and there's a warrant out for you on these cases and you didn't make bond on these cases and you're sitting in custody, you receive credit for that. That's the way credit goes. And legally, that's what you're entitled to. Now, somebody else will calculate your time. I'm not in charge of calculating your time. What ends up happening is I just will tell you, you get credit for any time served that you have been in custody on these cases. Then the clerks will calculate that time. If you believe that time is incorrect, there is a legal process where somebody else will look at it to see if it is correct. And if they say it's correct, then it's correct.
I understand everything you're saying. I mean, it's totally 100% correct. But when I get down there, they're going to start from my most recent one. So that's only 2 months back time. I got 8 months back time, 9 months back time on the other ones. I'm not going to see any of that. I'm going to end up doing 4 years.
Well, see, this is
4.5 months.
I don't think you're hearing me. So this is what I want you to understand.
They can't give me back time.
I'm not in charge of that. The state is not in charge of giving you your time. They can't say, I'm giving you this time. I legally will pass a sentence on you're getting credit for time that you've been in custody. When you go back to prison, if that's what agreement you worked out with the state, then the prison authorities are going to give you whatever time they deem you're supposed to get. If you don't think it's correct, what you're going to end up doing, an attorney may do it or you may do it, you're going to file a motion saying, I'm not getting appropriate credit. Then what will end up happening, it'll come back to the powers that will be, which will be this court, and I will receive notice from admin saying, we've recalculated the time is correct, or either they're going to say, the time is incorrect and this is how much time you should have. And if they come back to me and say, this is the time that you should have, I will sign it and it will go to the prison authorities and they will give you that time. That's how that works.
I understand that. But I just got indicted yesterday on the most recent charge. I mean, I had time to even look at discovery, but I haven't been able to discuss discovery or any case of defense against any of my cases. And yesterday was the second time I ever.
Here's the thing, you're here.
I was ever offered anything the second
Here's the
time,
thing.
Your Honor.
You're here, he's here. Look at the file.
I mean, I want to go to trial, but I can't. With
Okay.
him, I can't. He will not fight for me. I believe he's not going to fight for me. I need proper counsel, Your Honor. I asked yesterday. We've already. I'm trying to talk without cussing and getting.
No, you can go ahead.
Because like this is my life, right? And if I take it to trial, I'm facing 5 to 99. I know that I've already had affidavits put in. He won't turn it in. Right.
All right, so let me explain to you something about affidavits and the filing of affidavits. If these are affidavits from laypersons, that's not how it works at trial. They have to come in and testify.
Yeah, they're willing to do it.
All right, so then what will end up happening? Here's the thing. If you want to go to trial, guess what? In this court, you will get your jury trial. The jury will, if the jury find you not guilty, then they find you not guilty. If they find you guilty, you've already told me you're looking at 5 to 99 years or life in prison.
I'm not, but I don't have adequate counsel to go to trial.
All right, so this is what I want you to do. I want you to sit with your attorney and I want you all to go over the state's file. And this is what I'm going to tell both parties. Using profanity and anger is a sign of people not being intelligent.
Yes, ma'am.
So everyone should treat everyone with respect. I don't care who you are, what you do for a living. So you both are going to go over there, okay? And then if there's an issue, Mr. Hyde, do you still wish to represent him? That's either yes or no.
Yes.
All right, then have you been going over the documents with him?
I gave him the police report of the latest case yesterday.
I was just wanting to check that that was enough that you said he's talking about.
All right, so this is what I want you all to do. Sit over there, talk to each other, and then you can come back and talk to me. And if y'all cannot talk to each other civilly, then I'll go somewhere else. All right?
Okay.
So go over there, talk to each other civilly.
Bailey, thank you for the $5. I appreciate that. You said great show, super great pre-show as always, but today was special with the interview with Kaz. Show keeps getting better and better. Thank you, seriously. I'm sure I'm biased, but I'm really happy with what we're doing here, and I believe in it. We are by far not the biggest channel out there, but I would argue that we are the one building the best foundation. And I think that will help us be here and relevant and growing in the long run. So again, Bailey, thank you for the $5, and I appreciate everybody's support. Let's go back to Judge Brantley in Florida.
But he remained incompetent, but he was making great strides.
All right. Let's set this for a progress, maybe July, excuse me. You think that's enough time? Or is it too much time?
Let's do July, and if he's
Competent.
we'll bring him back earlier.
July 25th at 9:00 for a status review. July 22nd, I apologize.
Well, if they do, then we'll move you up. Okay. I'm keeping track of it. Okay. Yeah, that's it for today. Mr. Stevenson? Your Honor, Mr. Stevenson was on the prior trial docket and the state dismissed the new case. I made an Ori tennis motion to reinstate his bond, and you were not inclined to do it at that point. So I've formalized that for today's purpose. That's what's before you, is our request that the bond in case 223973, which is the sole remaining case, be reinstated based on the fact that the state dismissed the charge that ended up revoking his bond in the first place. He's been in custody for over a year on the case that was dismissed.
I still show that he has an open misdemeanor case, which was you arrested for on March the 28th. That's December 25-1450 for a violation of no contact order, which is still open and planning to go to trial down in misdemeanor court. So I understand that the previous reason for his bond being revoked, there's now a new reason to revoke his release.
And that case is against the witness that was uncooperative and resulted in a null pros up here, if I'm not mistaken.
Yeah, but basically the allegations of the null process is that victim was uncooperative with and there's allegations that the defendant was speaking to that victim on jail call. So I'm not inclined to grant the motion to reinstate the bond based on that.
We're scheduled for a trial management in June or July and an August trial, I believe.
All right, let's leave that on the trial docket.
Thank you, Your Honor.
I'll do that now. Is Kareem Williams?
Let's continue bouncing around as we tend to do here at the Courtroom Files Live. We'll go back to Judge Boyd.
Take your time, don't fall.
watching me watch me.
Let me just go to Odyssey real quick. Taking Odyssey a little bit of time.
Doesn't want to work.
Here we go.
It is disconcerting, and I do want you to wait for that. I had to come back today, and I want to work it out. He's having 5 volts on one. You still have to pay it off for those. It's almost, but actually it comes like down. And kill it.
All right, so CPS records, do you all have those?
They do have them. I've asked for a copy. I don't believe I've gotten them, but I'll get them, Judge. What I've been working with the state on is getting an affidavit of non-prosecution. I tendered that to them today, and I will e-file one with the court later today. So I'll be speaking to the prosecutor, but I think they have a request as far as scheduling.
Yeah, we just asked, it's currently set for discovery hearing, Your Honor. We asked for it to be set up for a plea deadline hearing. And between today's setting and the next setting, we're going to schedule an interview with the child involved in this case, as well as the child's mother, to, I guess, further determine what we're going to do with this case.
All right, your plea deadline date is June 9th.
Thank you, Your Honor.
And so on that date, you need to let the court know whether or not you're reaching an agreement. If you have not reached agreement, there's going to be a quick turnaround for a jury trial.
Thank you, Judge.
As of right now, we have not tendered an offer, but it's at the next setting, if everything goes according, we will tender an offer.
Oh, no, you all need to tender an offer because his plea deadline date is June 9th.
Yes, sure. We will. Thank you, Judge.
All right, they're going to give they're going to give you an offer today.
Okay.
I'll meet with him this week.
And counsel, if you could sign the acknowledgement of discovery.
Excuse me, Judge?
If you could sign the acknowledgement of discovery, thank you.
And you're on our back.
Yes.
My client now wants to talk to Mr. Porter, not me. I don't see Mr. Porter here, so I could be missing.
Okay. He'll be right back. I think he walked in the back. Oh.
It's said confidence. It's not I think it's here. All of it.
Let's head back up to Michigan and we'll say hello again to Judge, Judge see me lose my mind. Elmore. Yeah, Judge Elmore.
Involving a case in Lake County.
So we're here for final pretrial conferences in these 2 files. I'll note that the file ended in 3-9 as an alleged offense date of November 3rd, 2024. There was not an arrest until February 24th of this year. The other 2 files involve allegations, both with an alleged offense date of January 30th of 2025, and both resulted in an arrest on the same dates as the other file, which again was February 24th, 2025. We're here today for a final pretrial conference. These are some of the cases currently set for trial on June 10th. As we discussed elsewhere in this morning's docket, there are a couple other cases that are ahead of this case, or these cases, set for trial. But theoretically, they could go to trial. Mr. Harrison, what are we doing today, sir?
Well, there is no resolution, and we do intend to proceed to trial.
Is
The
that
37 and 39 have been glommed together.
37 and 39 or 38? 38 and 37 and 38 both allegedly occurred on the same date.
And those officers are with the CPD, correct?
Yes, I see.
Okay, so I got the numbers wrong in my head because there's one case that involves a Department of Natural Resources officer.
Yeah, that's
And go ahead, Lee.
That should be file ending in 39. I think that's the only file set for final pretrial today because we did submit an order to join the other two cases and adjourn those two cases as well.
I think I just signed that yesterday.
It was very
So
recent.
I think this was removed from the docket yesterday, that set of cases. So, but we are here on
39.
file ending in 39.
Okay.
Sounds like we need to.
I'm gonna take files 37 and 38 and note that those are adjourned. Let me fill out some paperwork here. All right, so I've adjourned files 37, 38. So now we're only addressing file 39. What's going on with that file, Mr. Harrison?
We intend to proceed with a trial in that matter, Your Honor.
All right. We will leave it currently set on a trial date of June 10th. However, Mr. DeMambro, I need to let you know, odds are it won't go to trial on that date. I will often have a couple cases set for trial on the same date. Because an emergency might occur, and if I'm able to slip in a case, especially one that only has 2 witnesses, then we can do so. However, I'm going to tell you that 2 of the cases that are before yours that are also scheduled to go on the same dates have been kicked around for a while, and they're getting old, and I'm pretty sure those are going to trial. When I do get to final pretrials, I always have a conversation with the defense. Now, because I can predict that yours won't actually go to trial on June 10th, then we'll have to come back here for another quote unquote final pretrial conference. At every final pretrial conference, I have a conversation with every defendant. And it goes like this. I can only do about 25 to 30 trials in a given year. I cover the circuit court in both Wexford and Missaukee counties. I handle on average about 500 felony cases a year. So mathematically, you can tell not a lot go to trial. But when we have a trial date, I don't want to lose that trial date. So what I tell defendants is on a final pretrial, when we know that yours is going to go to trial on the next trial date, which is in 10 days, I tell you today's the last day to enter a plea pursuant to a pretrial agreement. The defendant can always show up on trial date and plead guilty as charged, but I won't accept any reduced pleas. Now, that is not at all intended to pressure you, punish the defendant. I don't know anything about these cases, as you can tell. I just can read the charging document. I have no opinion. I don't know about the quality of the evidence, nothing. The reason why I have this policy is really for the 2 of the attorneys. I need to make sure that they have exhausted all of their brilliant negotiating tactics and stuff. What happens often is sometimes defense counsels will wait till the day before trial and go, aha, we're going to trial. I'll give you an easy out. No, your easy out should have been handled by the final pretrial. And the reason is because they have to call witnesses, subpoena witnesses. Subpoenas have to be issued by deputies most often. We have to get 60 potential jurors. All those people, and I've got to push off other trials.
I understand.
Yeah, so it's only to make sure that they are doing their jobs, and so we're able to have a trial. It's also to give the defendant comfort to know, well, I'm making a decision. This is what's going to happen. That's it. And so you know that your attorneys know, because they hear me say this every Friday morning, they need to have done their job by that date. So, all right. So we can never, ever take that as any pressure or any statement by me. In fact, it's also to help you because you have some idea that I'm making a decision and my attorney should have done everything by that date. All right, good. But again, right now, I'm predicting that we'll probably have to be back here again for another final pretrial. All right. Also, I make note of the arrest dates because you have a speedy trial right, which is typically 180 days. Now, when somebody is in custody, that 180-day clock is a lot more rigid. If I've got, let's say, 5 cases set for trial and only one person is in pretrial custody and the other 4 aren't, and even if they got charged on the same date, it's the one who's in custody that goes first. Now that 180-day clock can be moved depending upon who asks for adjournments. Judge, we need to look up some other evidence. We need to file a motion. Our witness is unavailable, yada, yada, yada. Then I can push out that 180-day. But I also highlight that, you know, when that clock started ticking for you, so you understand how important it is to make sure that your case is processing. So right now we're at about the 120-day mark. So I don't feel like we're at a speedy trial clock crunch. All right. I also asked this, Mr. Harrison, do you have any discovery issues, any problems getting evidence yet?
I don't think so.
Okay.
At least not that which would be provided by the prosecutor.
All right. So I highlight also here that in these files, we already have prelim transcripts, and my orders say that motions are to be filed within 30 days. That timeline can be extended, but by asking this question, if there's any motions, I'm notifying the 2 attorneys, hey, you're at that timeline. You should have already filed them, so get them done if you do have any. All right. And also I check with the defense to say, listen, did you not get all your evidence? Because if he didn't, then I can turn and wag my finger. But it sounds like I don't need to do so. All right. Anything else from you today, Mr. Carnes?
No, Your Honor. Thank you.
Folks, great. Thank you. We will adjourn this file as well and have it set for another final pretrial conference. Thank you. We are adjourned.
Okie dokie, let's try something new. We're going to go to Jefferson County, Texas. This is court at law number 2. This is Judge Terrence Holmes, who we have not visited with before.
How you doing, Mr. Hadley?
Doing great, yourself?
I'm doing fine, thanks for asking. Now, Mr. Hadley, the last time that you was here, April 15th, you signed a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And in that document, you stated that you wanted your case reset to hire an attorney. Is that correct?
Yes, sir.
Have you hired your attorney?
No, sir. I've been calling, but the ones I've been calling been out of my price range. Like it's been super, super high, and I haven't had the money that they wanted to. The ones that I thought they would represent me right. I've been trying to find something in my price range, so I haven't got an attorney yet.
Okay, now, Mr. Hadley. This case is an older case, and it's old because you were arrested late. I guess once it was filed, let me look at it right here. Yes. Case was filed and then you were not arrested. I see a motion. Apparently you had an attorney who withdrew And we signed the order for you to give you, well, for him to withdraw. And apparently after that, there was a warrant that was issued.
Yeah, cause I missed my court date, cause everything was going on, I just had the choice so long, court had just slipped my mind.
Well, now that the order was withdrawn in September, then you got rearrested in February.
Couple months ago, yeah.
Yeah, I mean, you've had since the last time your attorney withdrew to hire an attorney.
Well, I had to go to jail, I bonded out again, that was money, and
Yeah, but it was your fault.
I'm not saying it wasn't my fault.
Yeah, but I mean, so the court is not going to continue to
Well,
string this thing out because you've had enough time. We're gonna give you a last reset.
when I had Mr. Rennie 2 weeks before trial, cause I kept asking him, tell me I wanna go to trial. 2 weeks
Okay, well,
He went up like $10,000 2 weeks before trial, so that's.
well, that was between you and Mr. Rennick.
Okay,
But I'm just saying you need to, we're gonna give you a last reset to hire your attorney. Okay?
okay, so is it better if I just sign up for the public defender's office, cause I'm not working and stuff right now anyway.
Oh, well,
I
okay.
think I should do that then that way.
Well, I see why you were outside of your price range.
Yeah.
You was
I know.
not working.
I
Okay,
wanna do the best thing.
well, let's do this here. Our court administrator, she's going to give you a document. I'm going to go over those documents with you. Actually, I went over the document with you before. It's a judge's explanation. The bailiff is going to hand it to you. That's the same document that we went over April 15th. Okay, you can take a look at it. I'm going to go over it with you. Now, that document is titled Judge's Explanation of Rights to Defendants Without Attorney. And in that document, it states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you want an attorney to represent you, but you cannot, and you do not have enough money to hire an attorney, your case will be reset to give you time, and you cannot hire an attorney, then the court, if you request, can appoint an attorney to represent you. And the third option is, if you would like to represent yourself, you have to waive or give up the right to have an attorney. Now, that first paragraph, below number 3, it states that if you want an attorney, you have enough money to hire an attorney, your case will be reset to give you time to hire one. The second paragraph states that if you want an attorney but do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the questionnaire that they are talking about in that document is a 3-page document that is also on the clipboard that is titled Jefferson County Affidavit of Indigence. Now, if you turn to that document, you can turn to it right now. Jefferson County Affidavit of Indigence. Do you see it? Okay. You would have to fill out the first page of that document. Now turn to the second page. Now on the second page, you just have to fill out the top portion that is titled Defendant's Oath. And then the middle section that's titled Unsworn Declaration by Defendant. Do you see that? On the second page. At the top, it says Defendant's Oath. Paperwork is in.
There's waiver of counsel for this one.
No. Now go to the next page. Go to the page that says Jefferson County Affidavit of Indigence. Okay, and so it's a 3-page document. Okay, it's a 3-page document. The second page of that document is titled, at the top, you fill out the second page that's titled Defendant's Oath. And then the middle portion that is titled Unsworn Declaration by Defendant. Do you see that? All right. And then once you fill that out, then you'll stop. And so the next paragraph states that you may not talk to prosecutors about your case unless you first sign a waiver of counsel. Now, that is for individuals who will be representing themselves. They will have an opportunity to talk to the prosecutor, but they must first sign a waiver. You stated that you would like to see if you qualify for a court-appointed attorney, so you don't have to worry about that. Okay. Now, for individuals who are representing themselves, they should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. At the bottom of that document, it states that if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, there are some words in bold letters that state defendant's choice. You look at the bottom of that document. It states defendant's choice, mark initials next to only one choice. Is it right at the bottom? And then you will see at the bottom of that document, there are 5 lines to the left. If your choice is it's 5 little boxes or 5 lines at the bottom of that document. You see it?
Under the unsworn declaration?
No, I'm back on the first page, judge's explanation. I'm not on the affidavit. I'm on the first document that is on the clipboard. Okay, at the bottom of that document, it says defendant's choice, mark initials next to only one choice. Do you see that? And at the bottom of that document, there are 5 lines to the left. You're stating that you would like to see if you qualify for a court-appointed attorney, so you'll put your initials on the 3rd line to the left. And then you'll sign the document at the bottom where it says defendant, and then you will sign today's date, which is May 23rd of 2025, on the line that is titled date. Okay? Okay. So you can just go and have a seat. You got a pencil, an ink pen, a clipboard, you fill that out, and then we'll call you back up. Anybody ready? Okay. Jim Elkins? Oh, that's the deceased. Oh. Okay, so let me
Ready on David?
okay, well, it's not ready. So once this get ready, then I'll call your name. Okay, so Mr. What's his name? Elkins? Mr. No. Mr. Shane Hilton on Elkins.
So while he gets the next contestant, I gotta say I like him a lot. The gloves are throwing me off a little bit, but it's throwing me off because it's getting my brain moving. I don't have time to do it, but it is the perfect opportunity for somebody to take a clip of him and over those gloves edit in like some Hugh Jackman Wolverine hands. I think it would be hilarious. Anyways. Well, I guess he's going to be quiet for a bit. I'll keep an eye on him. We'll come back to him when he's got something going on. In the meantime, let's go back to Florida.
Representing yourself, I have found you competent to represent yourself. At any point in time, these proceedings, you can ask an attorney if he appointed to represent you.
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Okay. All right. Looks like there's been some, there's been a DCA case filed. I don't know if it's based on the discovery request or not. I don't know. All right. Yes, that's what it looks like. All right. Anything else today?
No, Your Honor.
All right. Yes, sir.
Yes, sir. Well, first, I would just like to request that my bond reinstated, sir.
Motion denied.
And reason being, sir, can I please have an explanation why?
Because you were out on bond, you picked up another charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted the case, that charge, is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up the fight.
Mr. McCoy, I've already made my decision when you entered.
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker, but however, you did enter a plea. And that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond.
All right, Mr. Clark. Can we discuss my case? I was here for a court date on my case.
Well, you've already filed a notice of appeal on the second request for discovery, so I don't know what else there is to discuss today.
Well, and that I was wanting to discuss, sir, is the fact that, my subpoenas and everything never got responded to. I filed subpoenas through the court and to the people about my the videos of my evidence, sir.
Well, if they've been served with subpoenas and they haven't responded, you need to do a motion for show cause.
Motion to show cause.
Yes, sir.
Okay. What about I just want to know your opinion, sir, since you're the judge.
I can't give you my opinion.
No. Based on the proceedings, sir. I was discussing with Mr. Frank Sullivan. I'm not looking for help. All the thing I'm asking, sir, is why am I been denied my evidence?
I don't know, sir.
Okay, if Bay County officers was the primary officer, sir, in my case.
Okay.
And they will only be an assistant.
I've heard this argument for ever since you've been arrested, so it's already part of the record. I've already made my ruling. You've already appealed that ruling, so we'll see what the first DCA says. I'm gonna set this for a pretrial June 19th at 9 o'clock. That'll conclude the hearing. Okay?
Well, sir, I still had a couple things I really wanted to say for the record.
Say them on the 19th.
Seriously, come on, Ms. Clark, man.
What do you want to put on the record? I'm gonna give you a minute. Go.
All right. The whole thing I want to put on the record, Ms. Clark, is I don't know what kind of beef that you got with me, sir, or Mr. Frank Sullivan, but I keep having multiple prosecutors filing motions against me, the ones that was pulled off of my case. Why they still filing motions
Mr.
against me.
McCoy, I understand that argument.
But it makes no sense because it seems like my case is going nowhere,
Listen,
especially when you have nothing to even
These
try
state
to do.
attorneys don't stay here very long. The ones that are on your case are in another division. I have nothing to do with that. Mr. Sullivan has nothing to do with that.
He just said he does.
Huh?
He just said he did.
No, what I said, Mr. McCoy said that despite who the prosecutor is, you're also involved in my case. And I said, yes, that is true because I'm the division chief.
I
didn't say I had anything to do with moving prosecutors or changing.
He doesn't move, but he is the division chief, so.
Okay, if
Request.
my old prosecutors already moved to a different division, whatever, why is she still filing motions against me? And then obviously when she signed it, she said this motion is for Frank Sullivan.
They all sign it for Larry Basford. It doesn't matter who signs it, who files it. They were filed on behalf of Larry Basford. So that's going to conclude today's hearing.
That makes
Y'all
no
go ahead
sense,
and
Mr. Clark.
Mr. McCoy, that concludes the hearing. I understand. There's nothing else to be said about that. Ms. Beasley?
Sean Golden. This is with Mr. White, and Mr. Golden is here before you in case 243310 for a bond hearing, Your Honor.
All right, you can call your first witness.
I call Sean Golden. Raise your hand. Promise swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, state your name for the record.
Sean Golden. Mr. Golden, you lower your hand, sir.
How long have you lived in Bay County?
Off and on, 20 years.
All right, and then most recently you moved back when?
Um,
Was that in 2020?
yes, ma'am.
Okay. And does your mother live here?
Yes, ma'am.
How long has she lived here?
20 years.
And where does she work?
She was working, she's at Supercuts right now on the beach, cutting hair.
And have you confirmed with your mother that you could live with her?
Yes, ma'am.
And are you able to post a $5,000 bond or $100,000 bond in this case?
No, ma'am.
And what kind of bond would you be able to post?
5,000.
All right. And do you ensure this court that if you are granted a reduction in bond and you're able to post your bond, that you will return for court?
Yes, ma'am.
No further questions.
Mr. White, any questions?
No, Your Honor.
Ms. Beasley, may I call your next witness?
That's the only witness the defense has, Your Honor.
Mr. White, do you have any witnesses?
No, Your Honor.
I'll allow you to make an argument. And Ms. Beasley, I'll allow you and, Mr. Golden to respond and make your argument.
Thank you, Your Honor. I've spoken to the victims in this case who are on board with prosecuting the defendant for what he did to them. He broke into their house, and when caught, lied about why he was there. He battered the owner of the father of the family and owner of the house during this incident. And after the incident, he hid from authorities and law enforcement for a week before he was found and discovered and eventually arrested. And this defendant poses a flight risk if he is released or if he is given a lower bond. Given the fact that he hid from law enforcement for a week prior to his arrest, we have no guarantee that he is not going to try and do that again in order to try and evade these charges.
Ms. Beasley?
Your Honor, this was a total misunderstanding. He was supposed to be cleaning units. His cleaning supplies were outside. When the gentleman came inside, it frightened him, and he ran out, and the gentleman was standing in the way. It wasn't that he battered anybody. And as for the state's argument that he's hiding, how can you hide if you don't know you have a warrant or don't know that the police want to talk to you? So, he's not a flight risk, Your Honor, and we'd ask that his bond be reduced.
I'm going to deny the motion. He's been charged with burglary with a battery, which is a first-degree felony. Punishable to 30 years in the Florida Department of Correction. I believe that the bond set is I know. I tell you what I will do. I'll lower the bond to 75,000. Okay.
And we need a tracking date. We're setting some depositions. Probably need the July.
July 24th at 9:00. Yes, ma'am.
Stephen Hutchinson. Your Honor, this is Stephen Hutchinson. This is with Mr. Sullivan. He has two cases with you, 25256 and 25528. And we're here for a bond reinstatement hearing. I don't believe that I need to take any testimony, just argument, Your Honor.
Okay. Okay.
So, Your Honor, in case number 25256 and 25528, he had posted his bonds totaling $14,500, and then he went up to Alabama where he has a 2022 VOP case, right?
No.
VOP, new law, a 2022 case up there. He posted the bonds up there, so now he's back here. So we'd ask for his bonds to be reinstated. And so we can move forward on with him out of custody.
What was it revoked for? A failure to appear?
He was in Alabama. So he was in Alabama in custody, and that's why he didn't appear here. But he had posted the bonds here and then went up there to Alabama to face those charges, posted the bonds there, and now he's back here. So he's done quite a bit of traveling in a very short period of time.
What's the state's position?
The state's position that it should remain held without bond, Your Honor. He was arrested in January on the 25256, bonded out, and then was rearrested for new felonies in 25528. And then obviously he's now got the additional charges in Alabama. So based off of his arrest in the 25258 case while out on bond, the state's position is that his bond should have been revoked based on that alone. And now that he is held without bond, he should remain held without bond.
How come they gave me another bond?
Yeah, I agree with the state. He picked up a possession February 22nd of 2025 and picked up the other. And he was arrested and bonded out on January 28th and picked up another charge. So I'm going to deny the motion to reinstate the bond. We need another tracking date.
We have a tracking date already of June 16th.
We'll leave that as it is. Do we have anybody in the Zoom room, Ms. Nelson? On Rebecca Falcon?
There is somebody that's labeled as a conference.
Let's go ahead and go back to Judge Holmes. Except for the fact that Judge Holmes has himself muted. That's not helpful. All right, let's go back to... Whoop. There he is. No, there he is not. Whatever, I guess. Let's go back to Florida then.
June 2nd.
Any objections?
I'm making an objection.
He's rejecting the misdemeanor, so.
Yes, Your Honor. I have no objection to removing him from the trial docket, but that misdemeanor offer is revoked if he's not taking.
William, you understand that? We'll set it, you want to set it for just a pretrial or a trial?
I'll defer to Mr. Meredith.
Either way, Judge. It looks like it's headed for trial, but I've tried to communicate with Mr. Williams.
Let's set it for June 9th. No, excuse me, June 10th at 1:30, and you're gonna meet with him this afternoon. And
Yeah, the investigator will.
oh, investigator. I mean, that's just as good. All right, just sign a note for that day, sir, and I'm gonna take it off the trial docket.
Thank you, Judge.
So who's gonna be representing me? I'll be representing myself.
No, I'm representing you.
Okay.
But you're not going to meet with me this afternoon. You're going to meet with an investigator and watch it. And then you can schedule an appointment with him. Okay? Just sign there. Judge, this afternoon, there's Jeremy Turner.
Does he withdraw?
What?
He withdraw to represent himself?
I don't know that
He didn't ever ask to represent himself.
he asked that I be removed.
All right, Mr. Turner.
There's a waiver on file for Mr. Turner. Mr. Sullivan, this is we want to get it done, but we knew we weren't going to get it done June 2nd. If we could have the October trial docket, that seems like it would be firm. And that's what Mr. Sullivan and I, we talked about August, but there's so many on August already.
All right, October for Turner, Mr. Sullivan.
Well, I told you, if October, it would be real firm.
October 6th at 8:30, September 19th at 1:30 for trial management.
Thank you, Judge.
All right. Let me.
Okay, let's try this again. Judge Holmes has moved on to the next contestant, and he has unmuted himself.
I am going to comment on he is
Invalid.
And then we take over the power or something. He is in
The ones out there was.
all it gets is social security.
Hold on. Next. Yeah.
Only to then remute himself. So this is a court that that I'm definitely gonna have to figure out again. This is our first day visiting with them, but they're a little quirky. So gonna have to figure out their flow so I can better understand how to present them to you. In the meantime, let's head west and go back to Judge Boyd.
All right. The last time you were here, and I'd like for people to feel as though, and not actually just feel as though, but to have had a chance to speak to the court, and it appeared that you wanted to speak to me.
Yes, I do.
All right, and what did you want to speak to me about?
I have a second to breathe. Kind of got worked up a little bit.
I'm sorry, what?
Can I have a second to breathe? I kind of
Sure.
worked up a little bit. Just pertaining the case, and I know when you went over it, you seen that the protective order was violated multiple times. It's not. I know it. If you read police reports or a person's victim's testimony of what happened, sometimes it could. It's up to the court, your discretion to see if, try to make sense of it, I guess. But when it comes to probably a protective order, we have children together, and to be honest, like I never been in any trouble before in my life pertaining like legal system and having to no contact, like the contact order with my children. And I was a sole provider for my children. Like she was a stay-at-home mother. And when I went back home, like the no contact order, I went back home, but I was the only person on the lease and I didn't have anywhere else to go. And honestly, from what we talked about pertaining me and her, we were fine on good terms, etc. So to be honest, I didn't think it was gonna be any more.
But see, here's the thing about it is that there's an offense against you for choking, right? And when you think about it, choking a person, that means you're face to face with them. They can't breathe and you're still choking them. Now you have that. So you have to know that there's a no contact order in place. And when you're saying, oh, well, I leased the apartment or the house or whatever, that's why I was going back there. Okay, I understand that. But when you were placed in custody at the jail, both parties agreed, your attorney agreed and the state agreed that you were actually contacting her from the jail. And so the thing about it is you already have this violent offense for choking someone. And then on top of that, you are continuing to contact them from the jail. You had to know you couldn't contact people from the jail. And that just shows the court that you can't follow rules. And she has, according to the testimony that is taken, she left town and is no longer in Texas or wherever she may be. Then, it is what it is. She left town. Maybe she left because maybe she's thinking, I leave town, he doesn't know where I am, then he can stop contacting me. But that's where we are.
Yes.
Sure.
Okay. See, I don't know how much I say before.
Well, you're not under oath.
Oh, okay. Well, I could speak freely. Yes. Your Honor, he came back and forth to see me unannounced, came to the house unannounced. When she was in a woman's home in Fredericksburg, she was they kicked her out of the woman's home, and the police had to come or whatever to escort her away. She came to the house on February 4th or 5th, unannounced, midnight, because I wasn't speaking to her because we were talking during the protective order. We have children. I was sending money for my children, or she would bring the children so we could see them. We would eat together.
Right, so here's my question. Were you sending money to the children from the jail? That's a no.
No.
But you were still calling her from the jail, and that had nothing to do with anything. So here's the thing. I wanted to hear you out because I know I didn't get a chance to fully explain to you why I didn't grant you probation. But the reason why I didn't grant you probation is because you have a crime where you choke her. And then after you choke her, you continue to contact her. What I'm letting you know is I understand, okay, you're on the lease, you go to the apartment or to the home because you're on the lease and you're trying to make sure that the children have food or have money. That's fine. But then you proceed to call her on numerous times from the Bear County Jail. That's a no. And for the court, part of the reason why I didn't grant you probation is because based upon your actions, you're telling me you can't follow conditions of probation. So that is why.
I Your Honor, if possible, like, because before this happened, I was enlisted actively in the military. I was enrolled into medical school for LMRT classes to become a radiologist. And my classes started in March 2025. I've been in and out of grew up in the jail, et cetera, house arrest, et cetera, since then. I understand exactly where you coming from and how it could seem to the court, or even like the charge, or et cetera. I've been sitting in jail and dealing with different health reasons, low potassium and low liver enzymes since the date of my arrest, December 5th to March 18th. I was admitted to the hospital. I had lost 110 pounds because I wouldn't eat because I had psoriasis, which is like my skin breaks out from certain foods, meat, dairy, etc., sugars, have you. I grew up in a family with my immediate household was my father, my brother, and myself. Out of us three, both of them are felons, and neither one of them graduated high school. I'm the only one who graduated high school. I'm the only one who wasn't a felon. So applying for the probation and adjudication was trying to save me from becoming a felon. I took pride in not having any criminal history. If you could so grant me, I don't have obviously lawyer here, but I was thinking
You can always come back with your attorney. I tell you what, I'll have you come back with your attorney. If you want to come back with an attorney, you can.
No, I'm just speaking to you. I mean, it's up to you. I mean, I just don't want to be a strain on my family, and being that I know that I would abide to any probation adjudication, especially the first. I can try to save my record and save me to be able to go on and have a career in any field or even enlist in the Army still. I would say if you could maybe think or ponder on doubling the sentence to 8 years, probation deferred, and double the fines. And if you could possibly consider a no harmful contact, because Carissa has my children, and Carissa has my children, she has my car, she has a bunch of my possessions. No, from our family, both of our families know each other. I knew Carissa since I was 14 years old. Both of our families know each other. Carissa doesn't, she's left her family.
Let me just tell you this. What I would suggest to you is speak to your attorney. The reason why I had you brought back is because I felt that there is something you wanted to say. And I know I didn't get a chance to explain to you why I made the ruling I made. And I will tell you, we're always taught as judges never to explain our rulings, just make the ruling and move on. But I don't like to do that because I don't want people to think that I haven't heard their story, or I'm not paying attention to them, or that I'm not looking at them as individuals. So I noticed as you were being taken away, you were raising your hand. And that made me realize that I really didn't get a chance to explain to you why I ruled the way I ruled. Now, if you're asking or wanting me to perhaps do some type of different sentence, and for me to consider that, then your attorney will need to file a specific motion for that. The coordinator will let your attorney know, and we'll go from there. Okay?
May I say something?
Sure.
I was told yesterday that my lawyer or attorney made motions for reconsideration and a bunch of other motions.
I haven't received those.
That's what I was told from my family. when I called. Before I went up here, it's all off the record.
Yeah, we're off the record.
Um,
The court reporter is not taking anything down.
I didn't understand what I signed with the silent.
All right, so here's the thing. You need to talk to your attorney about that. So everything else that you're about to say now, you need to talk to your attorney. Your attorney can file whatever motion she chooses to file, okay?
No, I was getting to what I was.
No, you're getting to places that
I
you
was
should not
stuck
get
there.
to.
I was stuck there, but I'm saying that before we came up here, I was told several times that I could be able to.
No. Here's the thing. You are now trying to, or well, attempting to wade into legal matters. And I think you should have your attorney here to discuss that. All right? So, Ms. Ferguson,
Yes.
has a motion been filed by his attorney?
I need to double check that, Judge, I don't, do you have his case number, Judge?
No.
They're right.
Okay. All right, and if they have filed, if she has filed something, we'll put it on a docket for it to be heard, and Ms. Ferguson will set it. So just have a seat, and Ms. Ferguson, if she finds something, we'll set it, all right? Okay, so when are we available to hear whatever motion she has filed?
I can do it the first week of June. I need to contact Anita to make sure she's available.
All right. So as soon as your attorney is available before 30 days, we'll hear her. Okay? And if you have some type of food intolerance, you need to let the jail know. If you let the jail know, they will prepare you a specific meal.
I literally, this is all in the notes. This is all the thing I told, when I had a Zoom court for the protective order hearing, I would go to Zoom court in jail, and I told,
Deputy Mejia,
Yes, sir.
will you please let the jail know that he has food intolerance to dairy?
Yes, sir. No, it's not just dairy, it's meats, processed foods.
All right, he can't eat any processed food. Will you let them know that he needs to eat green? Yes.
Your Honor, he needs to submit a sick call so they can verify he does eat, that he's allergic and can't tolerate that.
Your Honor, I can tell you exactly what happened. I was in jail for 34 days.
So here's the thing. The only question that I need to know is, did you submit what form?
This is, it's a lot of medical blood work. I took
Did
a lot
you
of,
submit it?
I've been in and out of, yes. I went to
No,
the
my
hospital.
question is, did you submit the form to the
Yes.
proper people?
Yes, several times.
All right, so Deputy Laura, if you can make sure that the jail has the information on him, and I will send an email.
And I didn't eat until I went to the hospital after 30.
I will send them an email about your intolerance. Is there anything else?
That's it.
All right, so I'm gonna send an email right now about your food intolerance. So what specifically can you not eat?
I was wanting to just get some type of fruit, and they didn't give me any fruit. They said because it's hooch and all this.
Okay,
other
this is
stuff.
what I want I want you to listen to me and internalize what I'm saying. As my grandmother would always say, it's not about who shot John right now. So somebody did something or they didn't do something. I'm not at that point right now. Where I am is you're telling me you have a problem. I'm trying to solve it. So I don't need to know the backstory. I'm just trying to figure out, what are you not allowed to eat? What can you eat? And I will send an email to the sheriff letting him know that you are not allowed to eat dairy. So other than dairy, what else can you not eat?
Meats, processed food. I just really fruits and vegetables.
All right, so you're not allowed to eat meats or processed food. And what are the results if you eat meats or processed food?
I have skin breakouts in my face and hair area, etc. And it gets like red irritants with psoriasis.
All right.
I didn't mean to agitate.
No, I mean, I just want you to tell me, what can you not eat? The fact that somebody is still serving you specific things, I'm trying to solve that problem, but I need to know what you can't eat. So you're telling me no dairy, no meat or processed foods, correct?
Yes.
All right. All right, thank you.
Thank you.
Mr. Ross, this one. Family violence, the excuse.
Alrighty, let's go to the 13th Judicial District in Kansas. If you've spent any time on LawTube, you know her, you love her, but we've not watched her on the live before. Let's go see Judge Webster.
And this is Mr. Williams, correct?
Yes, Your Honor.
We are on the record missing. We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. This matter does come on for preliminary hearing in case number GW 2025 CR 26, State of Kansas versus Alexander Lavon Williams. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
The defendant, Mr. Williams, appears in person via Zoom with counsel Christopher Ambrose, Farmers Legal.
And parties are ready to proceed with preliminary hearing.
Yes, Your Honor.
They
All
are.
right, Ms. Gillette, you may call your first witness.
Your Honor, will be calling Deputy Blake Fisher.
And I would note that the felonies that we're going to be addressing, count 1, Violate Offender Registration Act, count 1, and count 2, possession of opiate, opium, narcotic, or certain stimulant. The remaining counts are misdemeanors and 1 infraction. So those are the 2 felonies. Deputy Fisher, would you please start your video? Would you please raise your right hand, sir? Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may lower your hand, and Ms. Gillette, you may proceed to inquire.
Would you please state your name for the record?
Deputy Blake B. Fisher
And how are you employed?
by the Greenwood County Sheriff's Office
How long have you been so employed?
since December of 2019.
And were you on duty on Saturday, March 1st, 2025?
I was
Where were you on duty when you came across the defendant?
on US Highway 400 at the Greenwood Wilson County line.
And what drew your attention to the vehicle he was driving?
The vehicle had a defective headlamp.
Did you effectuate a traffic stop?
I did.
And when he stopped, where did he stop at?
At the approximate 351 mile marker in Wilson County, Kansas.
And did you call Wilson County officers also to the scene to assist?
I did.
And during that traffic stop, what was the first thing that you noticed when you approached the vehicle?
That the passenger wasn't wearing her seatbelt.
And what's the next thing that you did when you approached the car?
I asked for driver's license and registration, and both were provided.
And was there insurance on the proper insurance on the vehicle?
There was not, no.
And after gathering their information, what did you do next?
I went to my patrol vehicle and I ran the driver's license through my in-car terminal.
And when going through the in-car terminal, what did you find out about the defendant and the passenger?
The defendant was a registered sex offender, and the deputy on scene from Wilson County informed me that he had
Objection, hearsay.
Sustained unless he's available.
Now, besides finding out information from Wilson County, you noticed that he was a registered offender. Are you the offender compliance officer?
I am.
And do you routinely do offender checks for Greenwood County?
I do.
And is there a state system to monitor those?
There is.
Did you check later his offender registration?
I did. I believe I checked it on scene, and that vehicle he was in was not on his offender registration.
And did it appear to be his routine vehicle that was the vehicle he drove?
It did.
And did you look up his last several registrations?
I did later.
Was this vehicle registered on any of his last several registrations?
Not to my knowledge or that I saw, no.
After you dealt with running their information, what was the next thing that you did?
I approached the window and I asked for Mr. Williams to exit as his driver's license is not valid.
And what happened when you tried to take him into custody?
He became somewhat resistant.
And did you end up having to arrest him?
I did.
And did you pat him down?
I did.
Then what did you do next? Was the vehicle properly registered?
I don't believe so.
Did you make notes consistent with the time and date of when you had this case?
Video.
And do you have an independent recollection of it?
Jill, he's talking over me. And
I'm sorry, is the defendant's talking over you?
yes, he's saying lies, and when
Okay.
you're asking me questions, he's talking.
All right, Mr. Williams, you can't talk. You'll get a chance to talk to your attorney and see if you want to testify or not, but you can't just interject and talk over the officer. Make some notes and you can go in a breakout room with your attorney and talk about it after the testimony if you need to. But Deputy, please make sure he has something to make notes with so he'll remember what he wants to address with his attorney if he does. Go ahead, please.
Deputy, after you took him into custody, what was the next thing that you did?
I removed. I apologize. But while I was taking him into custody, I was removing a dagger from his person for officer safety purposes. I believe you asked me that question. And then once he was taken into custody, he was removed to the rear by my patrol vehicle.
Now, after he was taken into custody, was Miss Bolig taken into custody?
No, she was not.
And was she placed anywhere? This time frame was in March. Was it warm or cold that day?
It was colder outside.
And after she was did you take her out of the vehicle?
I did, and she was placed in the Wilson County Sheriff's Office patrol vehicle.
Was she patted down prior to being put in that vehicle?
She was. I asked for consent and she gave it to me.
And after you had them both in custody, or what did you do next?
I started to tow inventory log of the vehicle.
And at this point, was the vehicle legally insured?
No, not that I was made aware of.
And did the vehicle have legal tags?
No, not that I was aware of.
Right. So when you started the tow inventory, did anything grab your attention?
There was a plastic bag seated on the rear floorboard directly behind the front passenger seat of the vehicle.
And did you go to inventory that bag and see if there's anything of value?
I did. There was a pair of brass knuckles.
And after finding the brass knuckles, was there anything else on the back floorboard?
There was a container and that had a Applebee's label on it that contained an alcoholic beverage inside of it.
And were you able to determine whether or not it would have been alcohol?
Yes.
What did you do after you found the alcohol?
I started a probable cause search of the vehicle to ensure there was no other open containers inside the vehicle. While searching under the front driver's
Hang
side.
on, I'll ask you that part. You can't keep going. I gotta ask you questions. Did you find anything in the front driver portion of the vehicle?
Under the front driver's seat, I located a glass methamphetamine smoking pipe with residue.
And then, did you end up testing that residue later?
I did.
And, did you find anything else under or around the driver's seat?
There was another glass smoking pipe with residue that had been broken.
Okay. Did you locate anything in the center console?
May I refer to my report?
Will that aid in
Just
your
recollection.
recollection?
Yes.
And you may refer to it to aid in your recollection.
You asked specifically in the center console.
And, did you send the items to the KBI lab for testing?
I did.
Your Honor, I believe that Missy has the KBI lab in this case.
Missy, do you have that? Is that something we can screen share? Or do you want me to just look at that? If you have that and can screen share it, unless there's any objection to screen sharing. Is there anything on that, Ms. Gillette, that we wouldn't want publicly viewed?
No, it's the same kind of KBI report we always have.
Okay.
I actually
social-
don't have that one. I had the one from earlier, but I don't have that one.
Your Honor, I don't know why Missy doesn't have them because we usually email those. I would ask to present the KBI lab separately. So that's why they're usually pre-emailed to Missy.
Mr. Ambrose, is there any objection to her proffering the contents of that lab?
1 second, Your Honor.
Very well.
If not, we can use the field test results, Your Honor, for purposes of preliminary hearing.
I'm checking something, Your Honor.
Sure, go ahead.
Sorry.
Not a problem. Are you not at your normal desk, Ms. Gillette, where you can screen share it?
I am not.
Okay.
I have to pre-scan those, so.
Just, hey, for prelim purposes, Ms. Gillette, why don't we just use the instant test? I'm not seeing that I have a copy of the KBI result in my file yet. It doesn't mean you didn't send it. It means that I've not seen it in my file. So
Deputy, did you field test the residue in the pipes?
Yes.
And did they test positive?
Yes.
What did they test positive for?
Methamphetamine.
And was there other drug paraphernalia and drug found within the vehicle?
Marijuana.
Was that in the form of a vape pen?
Yes.
And that's labeled as THC?
Yes. And Jill, I'd like to restate, you had asked me if the tags on the vehicle were bad. They were not. It was only the insurance.
And I believe that covers all of the felonies, Your Honor. So I will pass this witness to the defense.
Very well, Mr. Ambrose, cross-examination.
Yes, Your Honor. So Deputy Fisher, you had indicated that you had stopped Mr. Williams, or you had indicated you were you when this occurred, when this stop occurred, was your vehicle stationary or were you patrolling?
I was stationary.
And was your vehicle at the 351 mile marker then?
No.
On the highway? Okay. Where was your vehicle at?
I was on the Greenwood Wilson County line, on the Greenwood County portion of the line.
And when this traffic stop began, was this vehicle what side of the Greenwood Wilson County line was this vehicle on when you hit your lights or however you began your traffic stop?
When I observed the violation, it was in Greenwood County.
And what time of day was it when the stop occurred?
Nighttime.
You had indicated that there was a defective headlamp, is that right?
Yes, the driver's side headlamp.
In what way was it defective?
It was going out. I can't recall if it was completely out. I mean, I know that it was not visible at least 50 feet in front of the vehicle. It was out or nearly almost out.
Next, you had, just so I'm correct, Miss Bolig was the passenger, is that right?
Correct.
And you had indicated that when you had walked up to the vehicle after the driver had pulled over, that you had indicated that passenger wasn't wearing a seatbelt at that point, right?
Correct.
Were you able to observe if that passenger had a seatbelt on while the vehicle was still driving?
No.
Okay. You had also indicated that at the time, the vehicle wasn't compliant, or at the time of the stop, Mr. Williams wasn't able to provide you with current insurance for the vehicle, is that right?
Correct.
Did he provide you an insurance card?
No. I can't remember if he did. I remember that we were on the phone with his mother. Miss Bolig did provide me an insurance card, but it was expired. And throughout the whole stop, we were on the phone with Mr. Williams's mother, and I was never provided with any current proof of insurance on the vehicle.
Okay, so but the insurance card you had been provided was expired then, okay?
Correct.
Do you recall when it had just out of curiosity, do you recall when it had expired?
I do not know.
And it's not in your report, is it?
I don't believe so, no.
Thank you. Now you had indicated that you are the registration compliance officer for Greenwood County, is that right?
I am.
Okay. What does that all entail?
Ensuring that everything on each offender's registration is up to date and accurate.
And with that, you are, have you had any extra additional training for that, or how did you become that individual?
It was appointed to me by the sheriff, and I have been to some training for it, yes.
What kind of trainings have you been to for it?
The KBI has hosted a training on it.
Okay. For, just so we're clear, what kind of training was that?
I can't recall. It's been years ago.
Okay. And, with that, I'm not going to ask that question. It's going to ask for him to draw a legal conclusion. I'll withdraw that.
Okay. Thank you.
And then, so in the course of this stop, you ended up doing you started out by doing a tow inventory, and then you found what you would believe to be alcohol in an Applebee's cup during that tow inventory. Is that right?
Correct.
Okay. And when your department finds what's presumed to be an open container, what steps are taken to ensure that that's actually alcohol?
I mean, there wasn't enough in the vehicle to send it off for testing or anything. Some of us have a PBT that reads it. I don't. I was just able to tell that it was alcohol based off the odor of it. And it was later admitted to me that Mr. Williams had been drinking from that cup, and it did have alcohol inside of it.
And was that a statement by Mr. Williams or someone else?
Someone else.
And Your Honor, I'd move to strike that as hearsay then, if that individual is not here to testify today.
Sustained.
Now, going back to this inventory stop to the Applebee's cup, and then as a result of that, you began searching the vehicle for other open containers, right?
Correct.
And during the course of that, you found these 2 pipes, right?
Correct.
Where were they located again?
Underneath the front driver's seat.
Both of them were?
What?
Or it was 2 pipes that were recovered, right?
Correct. Underneath the front driver's seat of the vehicle.
And in the course of that, in the course of the stop, did anyone take responsibility for those pipes?
No.
And you had tested them with an instant test kit, correct?
Correct.
What instant test kit do you all use?
The mobile detect.
And what is the procedure for the mobile detect kit for getting a result?
There's a strip, and you get some of the substance that's inside of the pipe onto the strip, put the strip in, it tests the substance, and I scan it with my phone, and it will detect or not detect whether there's an illegal substance.
Counsel, is this going to help on the probable cause for counts 1 and 2?
For the methamphetamine possession kit charge, yes, Your Honor, that's why I'm asking.
Okay. I thought you were talking still about the alcohol. I missed that.
No, I'm sorry, Your Honor. No.
No, you did it. You did everything fine. I'm sure I just missed the term.
Yes, Your Honor. And so was that the policy, was that the procedure you followed this evening, or the evening of the stop?
Yes.
Okay. And I don't believe I have any further questions of this witness, Your Honor.
Ms. Gillette, any redirect?
No, Your Honor.
All right. Any further witnesses, Ms. Gillette?
No, Your Honor, the state will rest.
Mr. Ambrose, any evidence?
I have a breakout room for 1 second with Mr. Williams.
Yes, certainly.
Judge.
Please, Missy, help them with that breakout room.
Okay, so the good news is we were a little bit in the Wayback Machine here. So I'm going to move us forward past their breakout room. Hang tight a second while I do that, so we don't have to sit here and wait. All right, looks like we're queued up.
W 2025 CR 26, State versus Williams. All parties as before. Returning from a brief recess, Mr. Ambrose, any announcements at this point?
Judge, we won't be putting on any evidence today. And I believe we'll be waiving any closing statements. However, I will ask to be heard on bond before we're done this morning.
Very well. Ms. Gillette, any closings?
Judge, I believe that he's driving a vehicle. It's his primary vehicle. It's not on his offender registration. Hasn't been on his offender registration for the last several registrations he's done as to count 1. Count 2, the methamphetamine pipes are under the driver's seat within reach of the driver in his car that he drives as his primary vehicle.
I do find that probable cause exists to bind this defendant over for arraignment. Missy, when will that be?
This case will go to Judge Hart. I have June 12th at 9 or July 3rd at 9.
We can do June 12th, if we might.
Very well. The defendant is ordered to reappear with counsel before Judge Hart for arraignment June 12th at 9 a.m. Counsel, you want to be heard on bond?
Yes, Your Honor. Right now, Mr. Williams has been in custody for a while, basically since this case got filed.
March 1st.
Yes, Your Honor. And he lacks the financial means to post bond at that level. However, in speaking with him, if the bond was to be reduced to $10,000 cash surety, I anticipate he would be able to post bond at that level.
So where does he live, or where is he from?
I can give you an address in 1 second, Your Honor. He'd be residing in Iola, and if I remember correctly, it would be with his mother.
Is that right, Mr. Williams?
Yes, ma'am, it is.
Did you reside with her before you were brought into custody?
Yes, ma'am.
All right. Were you employed when you came into custody?
Not at the moment. I was in between jobs.
All right. How long's your mother lived in Iola?
Oh, for a long time.
Okay. Ms. Gillette, your response to the motion to reduce to 10,000?
Your Honor, the defendant has a hold from Wilson County on a current active warrant, and did have one. I let the sheriff's office know that it is still popping up in Odyssey on his flee and elude case, to go over there and finish that case when he is done here. So I would say that the $10,000 cash security warrant is appropriate, or bond is appropriate on him.
All right, bond is reduced to 10,000, cash or professional surety required. Anything further on this matter? Make sure, Mr. Williams, that you have no alcohol, no illegal drugs in your possession or anywhere about. Don't go where it's being offered. Ms. Gillette, does he need to stay away from this? Was it the passenger you said in the car?
It would be preferable since she also was engaging in injury or habits.
Is she, what is she? Is she a wife, a sister? What's her relationship to you, Mr. Williams?
Soon to be wife.
Soon to be wife? Where
Yeah.
does she live? Does she live with your mother also?
No, ma'am.
Okay. Have you been having contact with her here in the jail?
I haven't had contact with too much of anybody.
All right, well, and Miss Gillette, was she charged with anything? I heard she wasn't.
She was charged with things.
Okay,
She wasn't. No, she
well,
wasn't.
she was not. Well,
No, she was not.
well,
I'll
I'm going to, I'm gonna, what's that, Miss Gillette?
I'll double check.
Well, for now, I'm going to order no contact, and then when you get in front of Judge Hart in a couple weeks, you can ask him about it. But if you haven't had any contact right now, you don't need to have any when you get out for a few weeks.
With my wife, I can't have contact.
What? You keep saying a lot of things kind of under your breath there. What did you say, sir? Do you want me to hear
I
it?
was speaking with the officer next to me. Thank you.
All right, watch your tone. Getting a little elevated there. Could get you in
And-
trouble.
Judge, we don't have anything else today. However, if I could have a breakout room with her real quick before we set off for today, I'd appreciate it.
With your client again?
Yes, Your Honor.
Yes, that'd be fine. And Deputy Fisher, thank you for your time. You are excused. Miss Gillette is excused, I think. And then as soon as you're through at the breakout room, we'll just close out because Missy, we don't have anything else until this afternoon. Is that right?
We have an 11 o'clock.
Oh, okay. All right. Now, is it on the same docket?
Yes.
Okay, then I'll just hang loose and they can go into a breakout room. Thank you.
All right, well, she hangs loose. We'll call it a day. I had fun today. I hope you did too. We had a great pre-show today. The Kazman, one of our channel members, joined us and shared a story about somebody he knew who did a very, very bad crime. So that was entertaining. The pre-show is fun. If you're not a channel member, consider becoming a channel member. It's a $2.99 investment to try it for a month, and I think you'll enjoy it if you try it. There's a link in the pinned chat, and we'd love to have you. Got to see a couple of new judges for this show anyways today, so that was good. And we get to go into a holiday weekend, which will be fun. But that does mean that we won't be here Monday. We will not be back until Tuesday because nobody's going to have court on Monday. But, well, I shouldn't say nobody. Somebody will run a first appearance, but that's not enough to do a show. But I will be posting videos throughout the weekend, so you can still find great content on the channel. And yeah, Michael, it was fun. Very fun today. Bailey, it was fun. Barbara, thanks. I enjoyed that. Yeah, Barbara, thanks for joining us from the UK. Appreciate that. Yeah, you guys continue to amaze me. Thanks so much for your support. Again, as I said earlier in the stream, we are not the biggest channel yet, but we grow every day, and I think we're building the best foundation here to be something special in the long term. So I appreciate all of you. But go have yourselves a great weekend. Stay safe out there, whatever it is that you're doing. Remember to honor those who have served our country on Monday. And I'll see you on Tuesday. In the meantime, like I said, we'll have content for you between shorts and regular videos, so take in those as you see fit.